for trying to, as it were, remove the obstructions, remove the obstacles. And then number 4, to see whether it works in the case of the Israel-Palestine conflict. Well, that having been said, let me begin from the beginning. Probably one of the best kept secrets, in fact, I dare say, the best kept diplomatic secret today is that there exists a consensus in the entire world community, with a couple of exceptions to which I'll return. There exists a consensus for resolving the Israel-Palestine conflict. It can be said, I think, that there is no conflict in the world today which is less complicated, no conflict in the world that is less controversial, no conflict in the world which is less complex, less intricate than the Israel-Palestine conflict. There is no conflict in the world where there exists so broad a consensus on the principle and the terms for its resolution. That sounds obviously like a very provocative assertion, and so now my task is to go beyond assertion to what would interest a rational audience, namely the evidence. So let's try quickly to go through the evidence. First of all, let's look at the most broadly representative political body in the world, namely the United Nations General Assembly. Every year at this time, literally at this time, November of every year, the United Nations General Assembly votes on a resolution titled Peaceful Settlement of the Question of Palestine. And the terms of the settlement are laid out every year in the resolution in virtually identical language. And the terms are the following: a 2-state settlement on the June 1967 border, which is to say Israel has to fully withdraw from the territories it occupied in June 1967, and a resolution of the Palestinian refugee question in accordance with the basic principle of the right of return and compensation. When I say a full withdrawal, the UN resolution is very clear. Israel has to vacate the whole of the West Bank, the whole of Gaza, and the whole of East Jerusalem, because it conquered them during the June 1967 war, and the basic principle of international law, grounded in Article 2 of the United Nations Charter, is that it's inadmissible to acquire territory by war. Israel acquired those territories by war. It has no legal title to them. Those are the terms of the resolution. I'll briefly go through the votes over the past 10 years, giving representative years. You can check yourself because it's on the web. Peaceful Settlement of the Palestine Question. You can find it at your own leisure. 1997, the vote, 155 to 2. The 2 negative votes, the United States and Israel. 2002, the vote, 160 to 4. The 4 negative votes, Israel, the United States, the Marshall Islands, and Micronesia. 2004, the vote, 161 to 7. The negative votes, Israel, the United States, Australia, Grenada, the Marshall Islands, Micronesia, and Palau. 2007, the last year, the vote, 161 to 7. Israel, the United States, Australia, the Marshall Islands, Micronesia, Nauru, and Palau. That means, well, for this year, the vote is occurring right as we speak, and it seems like Australia will this year join the rest of humanity. And so the vote will be Israel, the United States, the Marshall Islands, Micronesia, Nauru, Palau, and some years Tuvalu joins with Nauru and Palau. That's the vote every year. As the great human rights legal scholar John Dugard likes to put it, except for the United States, Israel, and those South Sea powerhouses, the entire world agrees on how to resolve the conflict. Some of you may want to say, well, the United Nations General Assembly is not just a political body, it's also a politicized body, and therefore we can't take these resolutions too seriously. I happen not to agree because the vote is so lopsided, so overwhelming, and so sustained over a significant period of time that the reasonable inference is this is not just political bargaining, but some basic principles are at stake, such that they account for the overwhelming support for such a resolution. However, for argument's sake, let's accept the UN General Assembly is a politicized body. Let's turn then from the most representative political body in the world to the most respected political body in the world, the International Court of Justice, the highest judicial body in the world. As it happens, in 2004, the General Assembly asked the International Court of Justice, which is an arm of the United Nations, asked the International Court of Justice to render an opinion on the legality of the wall that Israel has been building in the West Bank. In order for the International Court to render its opinion on the legality of the wall, it first had to render an opinion on the crucial issues bearing on the Israel-Palestine conflict. Some of you who are familiar with the lingo, the language of the so-called peace process, will know these issues as they're called the final status issues. That is to say, these are the issues which we're told are allegedly so complex, so intricate, that they have to be put off to the final stages of negotiations because otherwise negotiations will immediately break down, they being so complicated, so complex. Those final status issues are typically said to be the following. Number 1, borders. Number 2, settlements. Number 3, East Jerusalem. And number 4, the refugees. Those are those allegedly complex questions. The International Court of Justice, in order to render its opinion on the legality of the wall, had to first address 3 of those 4 questions: borders, settlements, and East Jerusalem. The refugee question didn't bear on the particular issue of the legality of the wall. I'll return to that in a moment. What did the High Court decide? It decided that, number 1, Israel had no title to any of the West Bank, any of Gaza, and any of East Jerusalem, because these are, to use the nomenclature of the International Court, these are occupied Palestinian territories. Why are they occupied Palestinian territories? Well, for the same reason as the General Assembly said, it's inadmissible to acquire territory by war. Israel acquired these territories in the course of the war. These territories have been set aside as the unit of self-determination for the Palestinian people. Israel has no title to them. They are very explicit throughout their advisory opinion. The West Bank, including East Jerusalem, and the Gaza are occupied Palestinian territories. Then they turned to the question of the settlements, and they said, well, under Article 49 of the Fourth Geneva Convention, all these settlements are illegal because it's inadmissible for an occupying power to transfer its population to occupied territory. On the 3 of the 4 questions that the court ruled on, as I said, the refugees we'll get to in a moment, it was a resounding defeat for Israel and a complete vindication of the Palestinian position. That's only half the story. The other half of the story is the vote itself. You would think if these were contentious issues, if they were controversial issues, if they were intricate or complex issues, you would think at the very least the vote would be close.